If you are audible, kindly check your audio. Yes, quickly, Your Lordships. So I'd like to mention item 54. This is a criminal contempt petition. Now, Your Lordship, the subject matter from which this petition arises is now pending in a civil suit. So may I humbly pray in my heart that this matter may be closed with liberty to the petitioner to approach at the appropriate time.
This is a contempt petition.
Yes, madam.
Then what happened?
Your Lordship, the subject matter from which this contempt arises is now in a civil suit, in a pending civil suit.
Oh, so you want to wait for the result? Of
Yes,
it?
yes.
Okay, then we'll close it.
Yes.
The learned counsel, Mr. A. Jimani, appearing for the petitioner submits that the subject matter for which this contempt petition arose is now a subject matter of a civil suit. And therefore the petitioner has preferred to wait for the outcome of the civil suit. the learned counsel submits that for that reason, the present petition may be closed and disposed of. Who is for the respondent? Hard MS, appearing for the respondents. Then after hearing both sides, the prayer of the petitioner is allowed. The present contempt petition stands closed and disposed of.
But liberty to approach it.
Liberty is given to the petitioner to approach this court
At the appropriate time.
at the appropriate time.
Much obliged.
Chair, I would mention item number 37. 37, 38, and 39. Lordship may see as our station, so if the matter can be listed after 3 weeks.
37.
37, 38, and 39.
The learned counsel MS so and so. You are for the respondent.
Yes, Lordship.
Appearing for the respondent submits that the learned conducting counsel, Mr. C.T. Jamir,
Yes, Lordship.
is not available today, and on that ground an adjournment has been prayed for. I have also heard the learned counsel, Mr. A. Jimoni, appearing for the petitioner. Do we have any objection?
He is tending to some matters in the principal seat.
That's principal seat.
Yes.
You want it to be?
No, my learned friend, Mr. Siri Jamil,
Ah.
he's attending to some matters in the.
Oh,
principal
I see.
seat. No objection.
After hearing both sides, the matter is adjourned today. When do you want it?
After 3 weeks, Lordship.
At least after 3 weeks.
Much obliged.
Yes.
I'd like to mention item 55 from the hearing, please, Your Lordship. 55, Your Lordship, from the hearing is, I'm praying on behalf of additional AG, we should pray, Your Lordship.
Hmm.
This matter may kindly be listed after 2 weeks, Your Lordship.
You have a
Petition.
petition. The learned counsel MS so and so, appearing for the state respondents, prays for an adjournment. I have also heard Mr. Taliao,
The Lordship, Foseko Fote.
Foseko Pate, appearing for the petitioner. After hearing both sides, the hearing is adjourned today, least after
2 weeks,
2
Your
weeks.
Lordship.
2 weeks.
Much obliged.
Obliged.
Your Lordship, I also like to mention item 40 on behalf of we should pray, Your Lordship.
40,
Yes, Your Lordship. This also after 2 weeks, Your Lordship.
40. The learned counsel so and so, appearing for the respondent, prays for an adjournment. I have heard the learned counsel MS,
To see no for the
appearing for the,
respondent.
you are for the petitioner.
For the respondents, Your Honor. The
Uh,
state has filed this appeal.
No, no, no. So here it is, you are appellant. So and so, appearing for an appellant. After hearing both sides, the matter stands adjourned today, least after 2 weeks,
Lordship, if it can be after 3 weeks, then
3 weeks.
Your Lordship, I also like to say this. Item 42, Your Lordship, similar, same prayer, Lordship, on behalf of we should pray, Lordship. 42, after 2 weeks.
The learned counsel, MS so and so, appearing for the state respondents. For the respondents, not state respondents. Prays for an adjournment. On the ground that the learned conducting counsel, Mr. P. Supre, is not available today. The prayer for adjournment is allowed, least after 3 weeks.
Your Lordship, I also like to mention item 43 and 44, these are analogous matter, Your Lordship. Here also on behalf of we should pray, Your Lordship, after 2 weeks.
The same order,
Yes, Lordship.
2 weeks.
2 weeks.
And Your Lordship. Same order for item 45 and 46 as well, Your Lordship.
45 and 46. There is the same order.
Lordship, and if these two matters can be clubbed together, these are analogous matters. Item
This
number 45 and 46.
45 and 46. Both these matters should be tagged together
After 3 weeks, my lord.
after 3 weeks.
Much obliged.
Your Lordship, I beg to mention item number 41. WPC 18/2024. Your Lordship, we have filed a detention revocation of the impugned order against detention order 13 May 2024. However, on 30 October 2024, the state government has revoked the detention. And for that matter, we would like to withdraw the writ petition. This,
You are Nancy Lotha,
cricket on
the learned counsel, MS Cricket Tono, appearing for a petitioner submits that the detention order for which this writ petition was filed has already been revoked by the state. So therefore, she submitted that she intends to withdraw this writ petition. So I have also heard Mr.
E.T. Pawan
Yeah,
for the state.
Waiting for the state. The prayer of the learned counsel for the petitioner is allowed. The writ petition stands disposed of on withdrawal.
oblige your Lordship.
Much obliged.
May I please, your lordship?
Yes.
Lordship, I beg to mention item number 2.
Item number
2,
2.
yes.
Yes, what do you want?
Lordship, kindly list this matter on 4th December. My senior Y.S. Manan has some personal difficulty today.
Okay.
My lord,
Yes.
may I please, your lordship? My
Yes.
lord, on date 4, I have some difficulty, so let the matter come on 28. Next week.
What do you say?
Lordship, my senior has some personal difficulties. He instructed me to fix on the 4th December.
Then you suggest another date? 7, 8, 9?
My lord, after 4, for me, it's very difficult. So, date 2
On 2.
is
On 2. The learned counsel MS,
The acronym,
appearing for the petitioner, submits to the learned conducting counsel. What is the name of your senior?
Y.S. Manan.
Is not available today. And therefore, she prayed for an adjournment. I have also heard Mr. So-and-so appearing for the state respondents. The prayer for adjournment is allowed, this on 2nd December.
much obliged.
Yes.
If I beg to mention item number 52.
52.
If this matter. can be
52 is listed with 51.
listed.
Yes, my lord. I appear for the appellant therein, my lord.
So you are paying for the appellant.
Yes.
Why these two matters are listed together?
My lord, they are challenging an order of the writ court whereby the circular permitting consumption of banning consumption of dog meat was challenged, my lord, and set aside. That notification was quashed, my lord. And both the appellants in these matters have challenged that order, judgment of the High Court.
What do you want now?
If I bring up the matter, then it fix up the 3 weeks.
Yes, do you have any objection?
My lord, we were prepared for arguments, but if a date has to be fixed, then no problem, my lord.
You suggest one date. He's asking for 4 weeks' time.
My lord, if the matter can be fixed on 11th December, 4 weeks might be a bit too much. 11 December?
11 December. Okay.
Yes, my lord. 11 December is okay from our side.
51 and 52.
Yes.
On the request of the learned counsel for the respondent. And after hearing both sides, the matter stands adjourned today. list again on 11 December.
Yes.
For hearing along with item number 52. Okay then.
I appreciate your lordship.
Yes.
Lordship, I beg to mention hearing item 53, Lordship. Lordship, here I am for the sole respondent.
Hmm.
I've taken the consent of the petitioner, Lordship.
Hmm.
We kindly release this matter after 2 weeks.
You're Mr. A. Joe,
B was our Lordship, on behalf of my senior agent.
the learned counsel, Mr. B. Koja. Appearing on behalf of Mr. A. Joe. Praised for an adjournment on the ground that Mr. Joe has some problems today. Mr. Koja further submits that he has already informed the others. Accordingly, the hearing is adjourned today. When do you want it?
After 2 weeks, Lordship.
List after 3 weeks.
I should beg.
Yes, your lordships. I beg to mention item number 3 to 36 on behalf of my senior legal counsel for the petitioner. Kindly grant us 2 more weeks time.
Three to 36.
Yes, your lordship.
The learned counsel, you're for a petitioner. You're for a petitioner.
Yes, your lordship.
The learned counsel MS
Loreno,
Loreno. Appearing on behalf of the learned counsel, Mr.
Miss Nidio Koza.
Praised for an adjournment on personal grounds. I have also heard the learned additional advocate general, Mr. So-and-so, as well as Mr.
And also
Mojo,
correspondent.
appearing for respondent number 4. After hearing both sides, the matter is adjourned today. When do you want it?
2 weeks.
List after 2 weeks.
Yes, your lordship.
Pleasure.
Your lordship,
Yes.
Your lordship, I beg to mention item 55 hearing item on behalf of CGC.
55 is already adjourned. It is already adjourned.
For motion, item number 1.
Your lordship, this is this open petition. Challenging against the detention order of the DTU under section 3(1) peace and abuse. The detention order is at annexure C1, page 89. And
29.
89. Annexure C1, 89. This is the detention order. And the confirmation order is at the annexure C2, which is at the East 9th Street.
You're pleased that the it was in English language.
English language.
That is why she could not understand it.
But there are other discrepancies while passing the order.
Okay, who is for the state respondents?
Okay. And for school 1 and 3, lordship.
1 and 3. Who is for 2? CGC? Did you inform him?
Yes, we have served the book.
You have served a copy. He has to come. Okay, respondent number 1 and 3. You have to file a reply.
Yes, lordship. And 3 weeks time, lordship.
Yes, sir. You want to file reply? Heard the learned counsel, Mr.
P.
Okay, appearing for the petitioner. Heard, Mr. One.
Yeah.
You were advocate general, additional.
So will be very apparent in this case.
अच्छा,
They accept the commitment, sir.
अच्छा,
That's a problem, my company.
okay. Appearing for the respondents 1 and 2. Heard the learned CGC. Give the name. Appearing for the respondent number 2. All the 3 respondents wait for some time to file a reply in respect of the present petition. After hearing both sides, the prayer of the respondents is allowed. When
It's really smart.
least after 3 weeks. Copy of the petition shall be provided to the learned counsels representing the respondents.
For hearing item numbers 47 to 49.
Yes, please. Yes.
Yes, that's your law. Notice, the main condition is in this, of the. Way out of four. After a decision has been made. By the village council. Whether to put the civil form in the field or. Before the issue is assisted, that was the question raised by the petitioner thing. All the analogous. Now. What should we can appreciate? Chapter 4A. Chapter 4A. The rules of the administration of justice in policy. Here, there is a provision.
The page number?
In my book. This is page 51.
51. Yes.
The provision has been given here, but it was not been given effect to. Now.
Yes.
Yes, we have formulated the. We have taken a decision. That the decision of the village councils, you go to this category of court. What should be greatly appreciate the decision taken by the cabinet. Thank you.
Yes.
Yes. Now, your lordship, once this chapter 4A has been given effect to, which we are proposing to give effect from 30/11/2025. The prayer of the petitioners will be taken care of.
The government is constituting one apex tribal court. Government will constitute.
Yes.
Yes, you say.
Lordships, by
Bring it out.
enforcing this chapter 4A of the rules. This is the constitution of the Customary Court.
Little more.
First it is the force, that's it. And the active body. Now, by enacting this or enforcing this chapter 4A, the problem now faced by us will not be solved. We have no objection in enforcement or operation of customary court. That we are not against it. We are in favor of it, in fact. One of the existing problem is that now after the 2013 Legislature General's is issued. Now the courts designated as regular courts by the judgment. Now they refuse to entertain appeals from the decision passed by the police councils or GPs or by the TVs. When we file an appeal before them, now they say that they have not been awarded to entertain the appeals. So now, because of that, several cases in Kohima as well as in Dimapur have been kept pending, awaiting the outcome of this decision. And because there is a difference of opinion, now justice has made this reference to a larger event. And so we need to go through properly the judgment passed in 2013. Whether there is the rules regarding Nagaland has been done away with. Because if you read chapter paragraph 13 of the decision, as well as paragraph 2, now the court has clearly made out that rules will not be applicable. But the practice of customary practices in view of 371A has been safe. And so in that view of the matter, the government is trying to bring out or enforce this chapter 4A with certain modifications and amendments. For that part, it's okay. But by solving that one, our problem will not be solved. So now this notification is supposed to be issued only in January 31st, 2025.
Yes.
January 31st, next year.
Next week.
What is no problem? It's all right. But before that is published, there has to be a way is be open to us for the pending appeals, which the district assistant judge or civil judge refuse to entertain. So that aspect also the government needs to look into in a short time. Otherwise, this will go on. Or direction may be given also to the state government.
Whether in this customary court, this chapter 4A, is there any a provision provided for the appeal from the customary court?
Your Lordship, under this, the initial lowest court is village court. Next is district subordinate customary court. And against the decisions of these two lower courts, appeal lies to district customary court. Now, as for this letter as submitted by the learned format of case, law department has been asked to set up a committee to examine the setting up of apex tribal court. Dealing with political issues slash disputes. But that is different again. That is totally different. Even if that is set up, they will not settle our issue. That is our problem, your lordships.
From appeal from district customary court goes where? Lies where?
As
Which
as
court?
per the amendment, I don't know whether that part is approved or not, but I heard that from the district customary courts appeal as to the commissioner or something. I'm not very sure. But that was at the draft stage. So as of now, I'm not sure. But this would be dealing with customary practices purely.
Yes,
Your lordship,
whether,
they appreciate. Decision of the village council will do the subordinate district customary court. Appeal in appeal. This is what we intend to do. Chapter 4 here. And decision of the district subordinate court in appeal will go to the district customary court. Now, your lordship may kindly appreciate apex tribal court to deal with intercommunal issues disputes. Here, Nagaland is a tribal society. Suppose there are 16 tribes in Nagaland. Suppose if there is a dispute between Angami Naga and Au Naga in Kohima, in that case, because customary practice is different from tribe to tribe. So because of this issue only, apex tribal
Your
court.
lordship, that is not an issue with due respect. That is not an issue. Let them go ahead with that part also. Well, no objection.
Worship, the of your another part, I would like to supplement. Regarding this chapter 4 was one of the issue in the present matters. And it was assured by the HE Nagaland that will be placed before the another court. So cabinet was considered on 16th of this month, and we have discussed the issue and they have approved this for the revision of this chapter 4A. So for today, your worship, as per the assurance given by the HE Nagaland, the government of Nagaland, we are submitting that the step taken by the state respondent. And there is essential issues related with these issues, the state will take them. But for today, as per the assurance given by our AG Nagaland, we are submitting the step taken by the state respondent.
Your lordships, that part is fact. Now, as per law order. Order dated 17/10/2024. Law order.
Yes.
Page. Number is not the first paragraph one. to paragraph 3, Your Lordship. The perusal of the reports placed before this court shows that the issue is with regard to the examination of chapter 4A of the rules for administration of justice, police, and 37, Third Amendment Act 1984. Whereas the issue raised in the present petition is with regard to the appellate forum, to which an appeal will lie against the order passed by the village authorities. Mr. Yan Gopal, Governor of the General, has however submitted the examination of the court, which has been raised before this court today, will also resolve the issues which has been raised in the present petition, and therefore submits that 5 weeks time may be granted to the state respondents to resolve issue on the subject raised in the present petition by allowing the government to deliberate on the issue raised in the case. Now, first part is they have done. They are willing to issue a application. Second part, they are silent. So let them do this part also. As submitted by learned AG last time, this is not an adversarial litigation. We are simply trying to solve an issue faced by the litigants, by the public, as well as by the courts. So this part also maybe steps has to be taken by the state government.
For amendment, for enactment of law or civil court act.
No, now whichever. But the existing problem is now from the decision passed by the like village councils, like overseas, like Gamboras, where appeal would lie.
Yes.
So
So what-
government taken some time, 5 weeks time
Yes, last time.
last time.
So
Now,
they-
now
they have
what is
to do
your
this
reply?
one.
You took time, 5 weeks time to deliberate on the issue raised in this case.
Yes,
Did you deliberate on that point?
Because this,
part is deliberated.
this minute was held in connection with the
4A.
chapter 4A only, it
Yes.
appears. And then the main issues raised before this court in this writ petition is with regards to the appeal, where the appeal lies against the order passed by the village authority. So probably whether the government is taking any steps to a state for enactment of civil court act or whatever may be to resolve this issue.
Question, the submission to the additional consideration already, but there is government court allow us to take a step, and that automatically is all interrelated. It is as submitted by petitioner council.
That means
not a problem.
you need more time.
Yes, we want some more time, and it is all related at all. Not only the litigant party, even the court also were facing some problem, procedural problem. And since we don't have enacted the civil court act also, and the Accra Bengal Act is also not practically is not applicable. So our state is trying to try our best to enact the civil court act also. So, and it's all related. So unless there's some more time is given, this is all related.
Okay, we will give you some more time
Yes,
to deliberate on this issue.
yes, Your Lordship.
Heard the learned senior counsel, Mr. R. Irano, assisted by L. Irano, appearing for the petitioner. Heard the learned petitioner, the general, Mr. Soyuz, appearing for the state respondents. Pursuant to the order dated 17/10/2024, the learned additional advocate general prays for some more time to deliberate on the issue raised in this case. Where after hearing both sides, the prayer of the state is allowed. When you will do that? After 4 weeks? After vacation. Least after the incoming vacation. I have also heard Mr. We have also heard Mr. So it's a very important respondents 4 and 5.
One other problem we have for respondent number 2 in civil division 6.
Give his name also. Okay.
For hearing, item number 50.
Yes.
Involved in this case, my lord. Yes.
Yeah, Mr. Lord.
Yes.
In this item, I am entering for respondent number 2. The principal accountant general lordship.
Yes.
So lordship, it's like in the main petition.
Hmm.
We have made a prayer for deletion of a name because we have nothing to do with this case, lordship. The accountant general office. Is this really a bank matter?
Yes, my lord. He was made a pro forma respondent, my lord. He may be deleted now because doesn't have a role to play, my lord.
I don't know today because I deal with government establishments, lordship.
He's a state bank of India, my lord. So in State Bank of India in pension doesn't, AG doesn't have any role to play, my lord. So
His name will be deleted.
yes,
Lordship, my respondent number 2 will be deleted for that.
Okay, I will delete it. But who is for respondent number 1? It is for hearing.
yes, for hearing, my lord, what has happened, my lord, the debt petitioner is claiming whether he is entitled to pension, my lord, under CCS rules, what has been submitted by him, my lord. So on this, my lord, the hearing took place and court made some directions on some forward findings and for which, my lord, we have withdrawn lordship, my lord. So background of the case is that, my lord, in 9/1/1991, the petitioner was appointed on the clerical cadre, my lord. He joined in 19/3/1991, my lord, as a cashier, my lord, and on 11/11/91, his service has been regularized, my lord. So thereafter, my lord, he was doing his job, my lord, but due to some, my lord, irregularities that he has committed, my lord, so he was put to suspension for another period, my lord. And thereafter, he was, by giving a sense of warning, my lord, service has been reinstated, my lord. Thereafter, what has happened, my lord, from 10/6/2022, my lord, he again remained absent, my lord. So for which, my lord, there was a provision under the SBI rules, my lord. And in terms of, my lord, the 8th bipartite settlement between the bank employees, my lord, and the management and the bank, my lord. So on which, my lord, the memorandum has been sent to him, my lord, saying that, my lord, you have to appear within the period of 20 days. And with reasons, my lord. So that has not been replied to, my lord. Second memorandum has been given, my lord, on 4/12/2006. Again, he was absent, my lord, and on 5/1/2007, another notice has been given to him, but he remained absent. The reasons for his absence, my lord, I will just later on, my lord. Thereafter, what has happened, my lord, in view of that, my lord, there is a provisions, my lord, that since he doesn't appear and doesn't turn up for the for his job, my lord, so his service has been voluntarily seized, my lord. He's on the role of this employment, his service has been seized. It's a voluntary cessation of his service, my lord. So thereafter, my lord, he has been informed, my lord. When this memorandum has been informed, my lord, he make a representation to us, my lord, on 27/27/2007, my lord, saying that, my lord, he requires some more time. Then, my lord, on my lord, this 11/7/2009, he was informed that he had been voluntarily seized, my lord. So thereafter, my lord, lordship may kindly come, my lord, at page. I will take your lordship to page 46 once, my lord. Because it is a case where now pension, whether he is entitled to pension is to be decided, my lord. But I am just trying to point out one thing, because the court directed to make a medical examination, for which, my lord, I have to make all this submission, my lord. I will take your lordship to page 46 once, my lord.
Yes.
Lordship sees, my lord, there is an unauthorized absence from duty, my lord. We advise that you are absenting from the unauthorized list since 10/10/2006. In these connections, please refer to the memorandum number so and so of dated 3/11/6, 4/12/2006, and 5/1/2007. sent to you your last record address by registered AD calling upon you to report for duty within 30 days of that notice. Now that you are failed to report by for duty by 5/2/2007, it is deemed that you have voluntarily retired from service on 10/10/2006. You are hereby called upon to pay the bank with 15 days of the date of the notice, 1 month salary and allowance in lieu of the notice, failing which bank will be constrained to file a suit for recovery of the same without prejudice. So this is how, my lord, he has been given this letter, my lord. So thereafter, my lord, my lord, he accepting the voluntary cessations, my lord. He, my lord, accepted, my lord, at page 72 be seen, my lord, can you?
72.
72, my lord.
Yes.
This is a letter from him, my lord, on 29/3/2012, my lord. The lordship sees the date, my lord, and down below 29/3. He has written to the Chief General Manager, State Bank of India. He is requested for payment of gratuity under Gratuity Act 1972. Here he has mentioned, my lord, I shall retire from service on the bank as per the close of business on 10/10/2016. In terms of the provision of the Prevent of Gratuity Act, I shall be glad you will please pay me the gratuity for which I am eligible. So accordingly, my lord, on this, my lord, application, the payment of the gratuity has been made out to him, my lord. On a subsequent, my lord, this next page, my lord, page 73, my lord.
Yes.
Page 73, my lord, he requested to pay the refund the provident fund balance amount, my lord. So there is also a letter to the trustee SBI provident fund. That is the authority who is dealing with the pensions matters, my lord.
Yeah,
So
has he received all those money?
yes, this money he has received. But the only questions, my lord, he have filed this petition before this honorable court on the premise that, my lord, that he has not received this notice and whether he is entitled to, he is asking for the invalid pension, my lord, under CCS rule. Now, in categorically, my lord, if the lordship sees his prayer, my lord, once, my lord, lordship may kindly see his prayer, my lord, at page 36, my lord.
Invalid pension.
Invalid, CCS pension rule is not at all applicable to the bank SBI employees, my lord. We have our own code. We have specifically rewarded this, my lord, in our affidavit in opposition. I will come to some of my paras of my affidavit oppositions, my lord. But that part has been totally ignored by the current single judge, my lord. Not been properly appreciated, my lord. So, my lord, may kindly see page 36 once.
Now, who gets invalid pension?
My lord, invalid pension is not a concept under the SBI, my lord. My lord, this is a case, my lord, where he has mentioned, my lord, in para 7 of his repetition, saying that, my lord, he got some problem, eye problem, my lord, for which he could not attend the office, my lord, and for which there is a provisions under the handbook, my lord. Let me furnish this copy once. What is the law to that regard, my lord? 6.
He was retired for his conduct, not for medical problem.
He was retired for his conduct, my lord.
Not for medical problem.
Not for the medical problem, because he never made any application before the authority regarding his medical problem, my lord. What he has accepted his cessation from his job. That is not an issue, my lord. Now the only issue before us, my lord, is that whether he is entitled to pension or not. Now he in the repetition itself he has prayed for pension. That is invalid pension under CCS rule. We say that there is no provision under in the concept of invalid pension under CCS rule, my lord. This is not applicable. Only the rule what is applicable before us is the SBI employees pension fund rules, my lord. So I am just placed the relevant portion of the rules, my lord. My lordship may kindly come to, my lord, page 12 of my this. This is a guideline which has been taken care of by the learned single judge, my lord.
Yes.
That is the handbook, my lord, volume 2. I will take your lordship to page 12, clause number 6, my lord.
Clause number 6.
6, my lord.
Page 12.
Page 12, my lord.
But in this, there is no.
No, my lord,
no 6.
I've given the page number, my lord. It is running number I've given.
The page number is page 12.
Yes, page 12, my lord. This is the top, my lord. I've given the number, my lord. Page number 12, top, my lord. Clause G, my lord. Page 12.
Oh, yeah, clause G is there.
Yes, G. He has been, my lord, relied on by the learned single judge, my lord. What is mentioned, my lord? If the employee is seeking voluntary retirement on the health ground before 55 years of age, he should be subjected to an examinations by the medical board consisting of a civil surgeon. Number B, a specialist relevant to the disease ailments and bank medical officer at local head office, general office. the medical board should be asked to unequivocally state whether or not the employee is permanently incapacitated and hence unfit to continue in service. If the medical board pronounce the employees to be permanently incapacitated, he should be retired from the date of medical report, provided not disciplinary action is pending contemplated against him. Now, my lord, on this basis, my lord, the learned single judge is directed to hold a medical examination of the persons who already retired in 2006, and the order has come up recently in 2023, my lord. Now, my lord, because of G, my lord, lordship may kindly see the age has to be there, my lord. So, in such a case, that means it is a case where, my lord, somebody wants voluntary retirement when one is in active service. Then only, my lord, this medical examination will come into play, my lord. So, here said in such a case, the employee's request, biodata and medical report should be forwarded to the concerned authority expeditiously along with the recommendation in the matter. The biodata of the employee should consist of his name, date of birth, age of the age or the date of retirement, date of appointment in the bank, designation at the time of initial appointment, present designation, total pensionable service, reasons for seeking retirement, whether any disciplinary actions is pending, contemplated, and details of the outstanding loans in advance and how the employees will liquidate them. So, my lord, this is for these two G and H has to be taken harmoniously, my lord.
Tell us another thing.
Yeah.
Whether in normal course, if a person retires from State Bank of India,
Yes.
does he get pension?
Yes, my lord. There is a quote I have mentioned, my lord. Lordship may kindly come to my lord. Then Lordship may kindly see, my lord, the next page 17, my lord.
Yes.
I will just read, my lord, the top, my lord. In exercise of the power.
Yes.
In exercise of the power conferred by Section 50 of the State Bank of India Act, the Central Board of the State Bank of India, after continuations with the after consultations with the Reserve Bank of India and with the previous sanction of the central government, hereby make the following requirement to provide for the establishment and maintenance of the pension fund for the benefit of the employees of the bank in pursuance to clause O of the subsection 2 of section 50 of the State Bank of India Act 1955, which regulates shall be known as State Bank of India Employees Pension Fund Rules. Now, my lord, lordship may come see, my lord, the fund shall be called as State Bank of India Employees Pension Fund. Now, my lord, the definition it says bank means State Bank. Who are the members, my lord? Means any persons in the service of the bank who has been admitted to the membership of the fund. And thereafter, my lord, number 3 may be seen. The trustee of the fund shall be the director. So, who manages, my lord, the fund, and who is entitled? Lordship may kindly see the next page 18. This 7, rule 7, my lord. Save as provided in rule 8, every permanent employee, including the permanent part-time employee who is required by the bank to work for more than 6 hours a week in the service of the bank, who is entitled to pension benefits under the terms and conditions of his service, shall become the member of the fund from the date from which he is confirmed in the service. Secondly, the date he may declare to become the member of the fund under the terms and conditions of his service. So he is entitled to pension. This is how somebody is entitled to pension. Now, 22 is very relevant, my lord. This is the rule under which whether he is entitled or not entitled has been decided, my lord. It says, my lord, the members shall be entitled to pension.
Page 22.
Page 23, my lord, rule 22, my lord.
Rule 22, yes.
Yes, my lord. A member shall be entitled to pensions under these rules on retiring from the bank service after having completed 20 years of pensionable service, provided that he has attained the age of 50 years. That means, my lord, first condition is that 20 years plus 50 years. First conditions. Or if he is in the service of the bank on or after 1193, after having completed 10 years pensionable service, provided that he has attained the age of 50 years. That means, my lord, his service, if it is after 1193, then after completing 10 years plus he has to attain 58 years. If his service is, my lord, if the service of the bank on or after 22/5/1998, after having completed 10 years pensionable period, provided that he has attained the age of 60 years. This is under 22(2)(1)(a), my lord. So number B says, my lord, after having completed 20 years pensionable service, irrespective of the age he has attained, he shall be satisfied the authority competent to sanction his retirement by approved medical certificate or otherwise that he is incapacity for further active service. That means, my lord, what after completing 20 years of service, my lord, if he is find that, my lord, he is not capable of doing the service, then he should be in active service. He should make an application before the medical board saying that he is incapacitated to continue. Then the medical board, my lord, as per 2G, will examine him, and thereafter, at the discussions of them, they will decide whether he can continue or not. But the condition is that he should at least complete 20 years of service, my lord.
Here, in this case, how many
In
years?
this case, my lord, 11 years, my lord.
11 years.
11 years. I have explained, I have details stated in my affidavit in opposition, my lord. This is what the pension court says, my lord. The thirdly, it says, my lord, the member who have permitted to retire under the clause C shall be entitled to proportionate pension. There is also a concept of proportionate pension. In a case, my lord, he cannot complete. Suppose, my lord, in a case he becomes medically unfit. So in that event, my lord, proportionate pension, there is a separate calculation how the pension has been ascertained. But he should complete 20 years of service, my lord. Now, my lord, in my affidavit, my lord, this is the rule, my lord. This is the rule. So now he has prayed in his writ petitions, my lord, that praying pensions, invalid pensions, which is not a concept under the pension fund, my lord, SBI pension fund, my lord. Under CCS rule is not applicable, my lord. As lordship says, my lord, it is the rules under the pension SBI Act, my lord. This fund has been created. So under that he is entitled. So now, my lord, may kindly see our reply, my lord, in para 55 be seen, my lord. Page 55, para 3, my lord.
Yes.
At the outset, the deponent begged to send an actual fact and circumstances involved in the instant case as follows: that the petitioner Sri P. Sani was employed in the State Bank of India and his service of tenure is as follows. Date of joining in the service of SBI in the clerical gate is 18/3/1991. Voluntarily cessation and vacation of his appointment is 10/10/2016. And since he was suspended for some period, 2006, my lord, total service period, that is 8/3/1991 to 10/10/2016 is 15 years, 6 months, 22 days. Suspension period, my lord, there is an order of the authority that not to take, not on spend on duty, my lord. So 1498 days has to be deducted, and period of unauthorized absence of 124 days has to be deducted, my lord. So out of deductions of this, his net service comes around, my lord, 11 years, 1 month and 14 days, my lord. So the petitioner was placed in a suspension from 25/4/98 to 3/5/2022 by the SBI controlling letters number so and so. The suspension period has been treated as not on duty. After revoking the suspension, that the petitioner was posted so and so and so. So ultimately, this is para number 3. His period of his 11 years, 1 month and 14 days. We have also explained, my lord, why he is not eligible, my lord, at para 4, my lord, at page 57, my lord.
Yes.
The petitioner is not eligible to pension, family pension, for the following reasons. The petitioner neither applied for retirement on medical ground, because there is nothing has been made in application for retirement on medical ground, nor the petitioner has completed 20 years of service, my lord. So the petitioner was eligible to refund of provident fund, balance credit and gratuity that was already been paid to him, my lord. Since not completed 20 years of pensionable service in the bank, petitioner not eligible to pension as per rule 22 of the SBI pension fund rules, pension rules, my lord. We have also explained, my lord, at page 58, para number 5, my lord, voluntary cessations, which my friend has not disputed, the petitioner has not disputed how this voluntary cessation has been made, and I will place some of the judgment, my lord, that voluntary cessation is permissible, my lord, has been not been interfered with by court, because this is a process, it's a settled law, my lord, already been decided by the apex court, my lord, and now he is also not disputing. His only prayer is that whether he is entitled to pension or not, my lord, under CCS. We make a statement, my lord, that he is not entitled because he has not completed 20 years of service, my lord. So, my lord, I will read, my lord, the para 6, my lord, where we have said about rule 22, as lordship has last read out, my lord, the employees pension fund, bank employees is governed under rule 22, which provides, as lordship, I have shown to your lordship, that we have quoted, my lord. And thereafter, we have specifically mentioned, my lord, that he is not entitled to pension as per rule 22 of the SBI pensions code, my lord. Now, my lord, I will take your lordship, my lord, to the judgment. I will just read the judgment. It is a small judgment, my lord. Why we have come before your lordship, my lord. Now, I will read from the very beginning, my lord. It will clear the facts also, my lord. Art Mr. So-and-so. This is the third time the petitioner has come before this court. Earlier two writ petition, there is WPC number so-and-so were withdrawn by the writ petitioner by seeking liberty to file afresh. Liberty was granted accordingly. This is how the petitioner is again before this court for this petition. The case of the petitioner is that he was appointed in the clerical cadre by the State Bank of India, Mokchong by letter number 9/1/1991, and he was confirmed in service by letter 11/11/1991. Even since his appointment, according to the petitioner, he was serving bank diligently and to the best of his ability. However, he started developing eye problem as he experienced blurring visions in both of his eyes. He accordingly approached the bank medical officer in the regional bank SBI on 14/3/2007. The bank medical officer referred him to go to Gauhati to seek further treatment from the eye specialist. The petitioner then went to the Gauhati and met doctors to the bank who had sanctioned the local head office in Gauhati. The doctor advised him to consult the eye specialist in the Nimtier hospital. The petitioner was then admitted in the Nimtier on 28/3/2007 to 31/3/2007. During his stay in the hospital, he received conservative treatment and he was advised to come back for further treatment after 3 months. Accordingly, petitioner, since he did not have means to go further treatment, he approached the office of the medical superintendent Naga Hospital, Kohima, for referring him for his treatment outside the state. However, the petitioner could not go for further medical treatment, and in the meantime, he was served with the communication of 11/7/2009 that I have read, my lord, stating that he was deemed to have voluntarily retired from service of the bank on 10/10/2006. That is, from the date from which he was found to be absent from the bank. Aggrieved with the same, the petitioner submitted his representation to the regional bank that he has that the branch manager Mokchong branch on 10/11/2004 for allowing him to avail the benefit of invalid pension on medical ground. Despite his application, the petitioner was not given any such benefit, and therefore he filed 2 writ petitions, and now the present writ petition is already stated here in above. Mr. R.S. so-and-so submits that the petitioner is a resident of interior village and doesn't have the proper process and procedure as to how the respondent authorities are to be approached. Besides this, the petitioner was in financial crisis coupled with his ill health, and for which he could not approach the authorities and also the hospital for his medical treatment. He therefore submit that the respondent authorities may be directed to consider his grant of his invalid pension as permissible under CCS Pension Rule 1972 or any other provisions of law. Mr. So-and-so standing counsel, on the other hand, that the petitioner never informed the bank authorities about his ailment. He also did not submit any applications for leave before, simply abstained himself from duty since 10/10/2006. The learned counsel submit that the bank authorities, on account of his absence, served 3 memorandum asking him to report for duty, which the specified period mentioned in the memorandum. However, the petitioner willfully did not respond to the memorandum and remained absent. The learned counsel further submit that against the last memorandum dated 5/1/2007, the petitioner responded by stating that his unauthorized leave may be converted to leave of any kind and he are still in medical rest. So, my lord, he is aware of this notice, my lord, and he responded to that, and I have annexed this copy in my reply affidavit, my lord. He submitted that the petitioner, however, failed to report back to duty despite his reply, and therefore the bank had no other options but to accept his absence as voluntary retirement from service intimated by the council. Accordingly, the communication dated 11/7/2009 was issued to him. The learned counsel further submit that the petitioner, pursuant to the issuance of the said communication, submit his applications for release of the gratuity and provident fund on 29/3/2012, 12/10/2011 respectively. Accordingly, the amount which was due to the petitioner had since released to him. Therefore, there is no question of granting invalid pension at this stage. Referring to the regulation 22 of the SBI Employees Pension Fund Regulation, the learned counsel submit that in order to grant pension, the minimum service required for the employee concerned is 20 years. The employee concerned can only be considered for retirement subject to the satisfactory of the authority to sanction retirement on being permanently incapacity or bodily or by bodily or mental infirmity from the further active service. It is after such satisfaction the proportionate pensions can be granted at the discretion of the trustee, my lord. Referring to the affidavit in opposition filed on 24/21, the learned counsel submitted the petitioner joined in the clerical category in 1991. He voluntarily abstained himself from service with effect from 10/10/2006. Also, the petitioner, on account of misappropriation of fund, was placed on a suspension for 1498 days, and he was unauthorized absent for around for 124 days. However, the petitioner can be reinstated back into his service, but it was directed that the period of suspension shall not be counted as a duty for any purpose. Accordingly, the net service period which remains is 11 years, 1 month and 14 days out of 15 years, 16 month and 20 days. With such kind of service, the petitioner is not entitled to avail invalid pension. Under the circumstances, the learned counsel submits the written petitions has no merit and should be dismissed. I have considered the submission made by the rival parties. I have perused the material on record. There is no dispute to the fact that the petitioner had rendered service from 1991 till he absent himself from duty on 10/10/2006, my lord. For the period he was placed in a suspension, he was resident in his service by 10/4/2022, which is annexed as annexure 1 of the counter affidavit of the bank. It is also seen that the petitioner had approached the medical officer of the bank at Dimapur, and also at Gauhati on account of blurred vision. The petitioner has also been admitted to name care at Gauhati on account of his ailment, but the petitioner did not bring this to the notice of the respondent bank, my lord. The bank has also issued memorandum to the petitioners on 3/11/2006, 4/12 and 5/1/2007, asking him to report back to duty. The petitioner, however, did not report back for duty. The bank then issued the communication dated 11/7/2009 to the petitioner stating that he was deemed that he has voluntarily retired from service as on 10/10/2006. This communication was made after 2 years after the last communication of memorandum issued to him on 5/1/2007. According to the bank, in order to keep pace with ever increasing customer expected technology initiative, the bank and the competitions in the marketplace, a need was felt to put in place a formal recruitment policy by the bank. The recruitment policy was formulated and approved by the bank in its meeting on 12/12/2003. The policy that is modified from time to time. Accordingly, the handbook is updated. What I have given, lordship. The handbook is updated on 3/6/2021, has been issued by the Human Resource Department of the SBI Corporate, clause 2.6G. That G, I have, lordship, your lordship has gone through of the handbook, provided follows. That has been, my lord, quoted, my lord. If the employee seeks BRS, my lord. But, my lord, the age which is subsequent to that, my lord, that the one should be in active service, that has totally been ignored, my lord. And that is the reason the finding is perverse, my lord. From the above extract, it may be seen that the voluntary retirement before hitting 55 years of age on health is permissible, subject to employees concerned being examined by the medical board, consists of a civil surgeon, specialist relevant disease, and the bank officers of the local head office, administration office. The medical office board is also required to state whether the employee concerned is permanently incapacitated and hence unfit to continue in service, provided no disciplinary action is pending or contemplated against the employees. This finding is perverse in the count that, my lord, he should be in service, then only, my lord, he can come, my lord. Otherwise, in a later stage, now, my lord, medical board at 2006 cannot be done because it has to be assigned at that point of time. And he never made any application. He is not disputing also to that effect, my lord. From the materials available on record, it is nowhere seen that the bank authorities have initiated any disciplinary proceeding against the petitioner for having been absent since 10/10/2006. Regarding this, my lord, no disciplinary action has been initiated against his absence since 10/10/2006.
Tell me one thing.
Yes, my lord.
Suppose a bank employee, after 10 years, he wanted to take voluntary retirement on personal grounds,
Yes, my lord.
whether he will be getting pension or not.
My lord, if he want to get the pension, my lord, he has to fit himself in this rule 22, my lord.
20 years.
Yes,
of service.
22, yes, my lord. In this 22, my lord, what has been mentioned, my lord, the whole, they have got a specific criteria, my lord. If he has to enter in any of the whole, my lord, then only, my lord, he will be entitled to pension, my lord. So, my lord, in the case, my lord, 22(1) says, my lord, first condition is that 20 years and he should be 50 years. Secondly, my lord, if his service is after 93, then, my lord, at least 10 years of completion of his service and his age should be 58, my lord. If, my lord, after 98, my lord, then he should complete 10 years, but his age should be 60 years, my lord. And thereafter, my lord, if he complete 20 years of service, then he can go for, my lord, medical ground, he can make an applications for his, my lord, BRS, my lord, on medical ground, my lord. Then medical board constituted, trustee at a discretion, he find that, my lord, because he could not continue, then only his, on medical ground, his service will be, my lord, will be considered, my lord.
If after 10 years on medical grounds he is given retirement, then he will get pension or not.
Then, my lord, the concept of proportion, there is a discretion of the trustee, my lord. Proportionate pension, concept of proportionate pension will come, my lord. But, my lord, one has to make an applications, my lord. But the finding, in our case, in the instant case, what I am trying to point out, my lord, the observation of the court regarding that the bank have from the material available on record, nowhere have seen that the bank authorities have initiated any disciplinary proceeding against the petitioner for having been absent. This finding is also, my lord, incorrect because I will make some submissions on this and some judgment to that effect, my lord. Because, my lord, the notice memorandum itself indicates, my lord, that my lord, a notice has been given to reply. If under reply he is not satisfied, then only disciplinary proceeding will initiate, my lord. But this is inbuilt that the public concept of natural justice inbuilt is there, my lord. So such issue has been raised earlier, and ultimately it has been settled down by the Honorable Supreme Court, my lord. I will place those judgment before lordship. I have a judgment on that to that effect, my lord. Secondly, my lord, although he was suspended from service at the relevant time, but a memorandum has already been drawn up on 2002 reinstating him. Okay. Therefore, upon considering the steps taken by the authorities and having regard to the petitioner had served the bank, this court is of considered view that the petitioner should be considered for grant of invalid pension. That concept is not available, my lord. As may be permissible under the rules, my lord. Accordingly, the respondent is directed to constitute the medical board, my lord. This constitution of medical board, my lord, to examine the medical condition of the petitioner in terms of 2.6G, my lord, cannot be made applicable, because this is only in connection to active service, not in the person who have already retired, my lord, because everything has been given, my lord, and thereafter 2G of the manual, which is a period of 1 month from the date of the receipt of certified copy of this order. The petitioner will be at liberty to produce all relevant medical document at his disposal before the board for consideration of the board. The board shall complete the examination within a period of 2 months from the date of his constitution. In the event the board is of the opinion the petitioner is or was medically unfit for service, the report shall be placed before the respondent number 2 regional manager SBI Nagaland for decision by appropriate authority of the bank. So whether the petitioner can be given invalid pensions. So, my lord, the finding of the court, my lord, that regarding invalid pensions is not at all there, my lord. Secondly, my lord, the constitution of the medical board, that is only for the active service, not after retirement, my lord. And my lord, whether he is entitled to pension or not, my lord, as per my scrutiny of the records, my lord, I find, my lord, because he doesn't put in any of the pigeonhole that has been given under Rule 22, my lord. So, my lord, my submission is that the finding of the perverse, my lord, and my lord, one aspect of them, I'll just place some judgments, my lord, to that effect, my lord, because my learned single judge has held that, my lord, not disciplinary proceeding has been initiated because person was absent from 10/10/2006. He was given memorandum and he was given nothing has been given to him. So natural justice has not been followed. So nothing, not disciplinary proceeding has been initiated. To that effect, my lord, I have got some judgments, my lord. It has already been settled down, my lord. I will just take up the first one, my lord, the syndicate bank versus General Secretary 2005 SSC 65, my lord. This is also a case, my lord, where my lord, the persons, my lord,
Punjab and Sind Bank or Syndicate Bank?
My lord,
Syndicate Bank.
Syndicate bank, my lord, first, my lord.
Yes.
Oh, sorry, my lord.
The
first one, 2001, 1 SSC, my lord, 214. That is Punjab and Sind Bank and others, my lord.
Yes.
This is also, my lord, if I read the first line, my lord, the respondent challenged the order of the termination effect by means of striking him out his name from the muster roll of the applicant bank. My lord, I will read down below. The applicant pleaded that the respondent has remained unauthorizedly absent. The last, my lord, 5-6 lines from the below, my lord, that is a fact on that page number 215, my lord, on that page, my lord. The applicant pleaded that the respondent had remained unauthorized absent for a period of 180 days and therefore made liable to be removed from the roll of the bank in terms of para 17 of the bipartite settlement of para so-and-so of the Customary award. The High Court took the view that the respondent has put in 16 years of service and his service could not have been dispensed with except after an inquiry consistent with the principle of natural justice, and the appellant actions in terminating the service of the respondent is based on misconduct in respect of which no inquiry has been held, though it is imperative for the appellant to hold and serve the charge sheet to him an opportunity to file reply, to appoint an officer to permit the respondent to adduce evidence in support of the allegation misconduct and give opportunity to give him refute such evidence. The High Court relied on certain judgments and so, my lord. Ultimately, it was held, my lord, that the normal proceeding of disciplinary action should be there, my lord. But in case of a bank, my lord, it is different, my lord. This has been held, my lord, by the Honorable Apex Court. I will read, my lord, para 4 and 5, my lord.
Yes.
A reading of the clause 14 of 6 bipartite, the 4th bipartite settlement will clear that in the event an employee absent himself from duty for 90 days or more
consecutive days beyond the period of leave originally sanctioned or subsequently extended, the management may at any time thereafter give a notice to the employees at the last known address, calling upon him to report for duty within 30 days of notice, stating entirely the ground for the management coming to the conclusion that an employee has no intention of joining duty and furnishing necessary evidence wherever relevant, and unless the employee report for duty within 30 days of the notice or gives an explanation of his absence satisfying the management that he has not taken up any other employment or avocation, that he has not intention of not joining the duty, the employee will be deemed to be voluntarily retired from the bank service on an expiry of the time fixed in the said notice. In the event the employee is giving a satisfactory reply, he will be permitted to report the duty thereafter within 30 days from the expiry of the aforesaid notice without prejudice to the bank's right to take any action under law or rule of service. Under this rule, the employee is given an opportunity to rejoin the duty within the stipulated time and explain his position to the satisfaction of the presumption will be drawn that the employee does not require the job anymore and he will stand retired from service. Thus, there is no punishment for the misconduct, but only to notice the realities of the situation resulting from the long absence of an employee from work with no satisfactory explanation thereto. The principle of natural justice cannot be examined in vacuum without reference to the fact situation arising in the case. This rule has been incorporated in an agreement where representative of an employees union where the party, they are also realized the futility of continuing with the situations when an employee without appropriate intimation to the management is playing the throne. If the respondent has submitted an explanation regarding his unauthorized absence or placed any material before the court that he had report for duty but was not allowed to join duty, inquiry may have been necessitated but not otherwise. In this case, the respondent employee has defaulted in not offering any explanation regarding his unauthorized absence from duty, nor he has placed any material to show that he has reported for duty within 30 days of the notice as required in clause 16 of fourth bipartite settlement. I will just show that is also been there in our also. Thus, we think that the contention put forward on behalf of the respondent that he was suffering from some serious eye ailment at the relevant time is difficult to accept. So ultimately, the court come to a finding that the judgment that has been given by the Honorable Apex Court in the circumstances, we find that the High Court has proceeded an erroneous basis of non-compliance of the principle of natural justice, whereas the true content of the principle of natural justice should have been borne in mind, particularly when there was an agreement between the parties as to the manner in which the situation should be dealt with and consequence that would cause thereof. So ultimately, my lord, now my lord, I will read the next judgment, my lord. Why I am submitting, my lord? Because my friend, my lord, the writ petitioner doesn't have challenged, my lord, his VRS, my lord, his, my lord, voluntary cessation of service, my lord. He doesn't have challenged that. I am only submitting because of the finding of the court, my lord. Not relevant in this case, my lord, but only because the court has come to one finding, my lord, that against this absent, my lord, no disciplinary proceeding has been initiated. So just I want to substantiate, my lord, disciplinary proceeding will be initiated when it has been held, my lord. When the ground given is not accepted, my lord, then only disciplinary proceeding will be initiated, my lord. Because he has given a ground, we said yes, this is a good ground, so no problem. But when we say that the ground you have given is not proper, then disciplinary proceeding will come, my lord. But opportunity of principle of natural justice being followed because he has asked for reasons and join. But in our case also, he doesn't turn up to join. He even not even make a mention, nothing, my lord. He doesn't turn up. And he has not disputed to that also, the voluntary cessation. What he is praying now, my lord, whether he is entitled to pension or not, at the stage as it is, my lord. And my lord, the learned single judge, my lord, only come to a finding, my lord, that the medical board has to be constituted. We say that this is forwards only because of the fact, my lord, because 2G is applicable in case of a person who is in active service, my lord. If somebody wants voluntary retirement on medical ground, if he is in service, then only he should make all that. 2G age is very clear. If you want to make an application for voluntary medical ground, then you have to give everything. Your date of appointment, your joining and everything has to be explained. In age, I have lordship has seen. So 2G and H has to be harmoniously heard. It is for the active service persons, not for the person who already retired, my lord. And medical board cannot decide a case of 2006, which has already been already we retired much ago, my lord, 10, 12 years ago, my lord. That cannot be made, my lord. So these two finding, my lord, we are saying this, my lord, is my lord.
Okay, all right then. Who is for respondent number 1?
And is it?
Yes, please.
Yeah, please, Your Honor. Actually, let me the clarification about the annexure 2, annexure A2, the page number 61.
Yes.
Yes, annexure 61C. Proceed. The authority empowered in sanction the requirements of the employees should constitute a mitigate board for the purpose of the constitution of the mitigate board may be on the same line and that done in the scheme for compassionate employment and medical board also constitute should be the medical authority verified about the permanent incapacity of the employee if the employee is the member of the pension fund, no minimum to pensionable service need be specified. And this would defect the purpose of the group corporate and center data number and so. Actually, this is his affidavit, Dorsey. He already admitted there is no, if the medical board is sanctioned the person who have been disabled, then there is no need to specific period. But the rule 22 is like the 50, should be completed 50 years, it should be such and such. But regarding this, actually, the petitioner is having to follow follow the rules. Actually, let's see, page number 39. Actually, the petitioner already, who are declared the pension is already confirmed the service. Proceed. Then he seek that page number 40. Proceed.
Yes.
Yeah. Actually, he took the took the permission from the concerned medical officer. Actually, vision is not the property, but they can't work property such and such. But this is the verbally the petitioners the approach to the respondent number 2. He is the regional manager, the division manager. Actually, he's saying like that. I could not work properly, but if possible to post it in storeroom, I can, but in case matter, I can't do anything. Such and such. He verbally approached to the such and such, but the division manager, the director to you concerned to the concerned doctor, and you're going to be treated and where which will be better, such and such. But he concerned the doctor.
No, he did not file any application to it.
No, my lord.
No, he already filed.
No application, my lord, for my lord medical examination.
He already given the application, but he cannot work further. But I filed additional affidavit. Additional affidavit. Page number 27 to 2007.
Voluntary cessation was of prior date
No,
of 2006, my lord.
As mentions about the captions, please kindly grant the 15 days for further the 3 months also and the still the waiting and find such instances. But Roshit, actually, you already given the, I mean, termination, but see, in nature, it is not he already removed the service, but he called for promotion exam 2007, 9/12/2007. Notification is there, Roshit.
Page number?
Page number 9. Roshit, I filed the additional bit with page number 9.
Additional affidavit. Reply. Yes, page number 9.
Yeah, Roshit. The 9/12/2007. The before that, then July in 2009 is also. The 5 July, page number 10.
When he was retired?
He came on 10/10/2006, my lord.
So you given the
Voluntary cessation, my lord, on 10/10/2006, my lord, and he is aware of the fact and he has written the letter, my lord, on 27/2/2007.
If he terminate the, I mean, terminate the service, then what he doing like that, Roshit?
My lord, this is a letter that is
Actually, in
issued,
the
my lord,
affidavit, the
doesn't
affidavit
regulate
also,
the service, my lord. This is, my lord,
Roshit, he already admitted in the affidavit, page number 61.
and this is also not part of the writ petition also, my lord.
If
Subsequently,
if
part
the
of the record.
medical board is sanctioned the unable or, I mean, disablement, then I already filed the medical board certificate is also. But there is no specific theory.
Legal board has to be,
No, actually you admitted your affidavit.
my lord, the rule, my lord, says, my lord, if somebody
No,
is
rule-
unwell, my lord, he has
Rules
to
already
make a-
admitted, rules already admitted, Roshit, page number 61. See again.
This is something different, my lord. It's
No,
not a part of the record, and this letter is, my lord.
why you file the affidavit, see, the authority empowered to sanction the retirement of the employee should be constituted the medical board for the purpose, the constitution of medical board may the same line and that is done and still.
Okay, we have already heard you. Both sides.
Most of all, the criticism of the report, nothing is written about the pension, 6 years pension rule. Those, our work comes, only when the pension rules is interpreted, as far as age is concerned. Now, the court has gone into the rules of the SBI pension fund.
Okay, your name will be deleted today.
Lord,
Heard Mr. G. Alam.
Roshit, actually, Supreme Court 2015 is already stated that the page number, page number 451, the para number 493, page number 73, para number 73, 80, 81 is already stated that central rule can be constituted.
Give us the copy of the judgment. Okay, heard Mr. G. Alam. Good night. Heard Mr. G. Alam, appearing for the appellant. Heard Mr. R.A. Rongmei, appearing for the respondent number 1. Pair. The learned counsel, Mr. N. Mojui,
standing counsel.
the learned standing counsel for the respondent number 2, submits that he has no role in this case Therefore, his name should be struck off from the title page of the memo of appeal. Stop. Mr. Alam has agreed to that and submitted that his name may be struck off from the title page of the memo of appeal. Accordingly, the name of the respondent number 2 shall be struck off from the title page of the memo of appeal. The matter is reserved for judgment.
My lord, what I'm paying only one thing, page 43 we've seen also in my spiral bending, my lord. That is regarding voluntary cessation, my lord. That is a voluntary cessation when it is done, my lord. Clause 33 is there, my lord. So I have given the page 43, my lord, it is there.
Okay,
Lord, she will-
Yes.